There is a date on the calendar that Washington has been watching for weeks. May 29th. That is the day Pam Bondi is scheduled to appear before the House Oversight Committee, under oath, on the record, about the Epstein Files. And the reason that date matters as much as it does is not just because of what she might say. It is because of everything that had to happen to get her into that room at all. Let me walk you through the sequence, because the sequence is the story. Bondi was confirmed as Attorney General in early 2025. One of the first major tests of her tenure was the Epstein Files Transparency Act, a bipartisan law passed by Congress, signed by Trump, that required the DOJ to release its full archive of Epstein investigation materials by December 19, 2025. The DOJ missed the deadline. Bondi's department cited the volume of material and the need to protect survivors through careful redaction as the reasons for the delay. When the files finally came out in January 2026, survivors and their lawyers described what they found as the single most egregious violation of victim privacy in one day in United States history. Survivor names were exposed, home addresses were visible, unredacted photographs of young women appeared in the public release until the New York Times called to report them. Meanwhile, the names of the men who abused those same survivors remained redacted. Attorneys for survivors said they had given the DOJ a list of 350 victims' names specifically to prevent this. They said a basic keyword search would have caught the errors. The DOJ did not perform one. The House Oversight Committee moved to subpoena Bondi. The subpoena passed 24-19. It was bipartisan. Republican members Nancy Mace, Lauren Boebert, Michael Cloud, Scott Perry, and Tim Burchett all voted in favor alongside Democrats. Bondi was scheduled to testify on April 14th. On April 2nd, Trump fired her. The moment she was removed from office, the DOJ argued she could no longer appear in her official capacity. The department said it would not send her to the deposition even though the subpoena named her directly and personally, not the office she had held. The subpoena did not go away when the title did. That is not how subpoenas work. But the DOJ said otherwise, and Bondi did not appear. Democrats on the committee filed a civil contempt resolution on April 29th. They said Bondi had illegally defied the committee, skipped her deposition, and refused to cooperate. Garcia described weeks of zero communication from Bondi, her attorneys, committee Republicans, or the Trump administration. He said the committee had made repeated attempts to make contact and received nothing in response. 45 minutes after the contempt resolution was filed, Republicans on the committee announced that Bondi would appear on May 29th. Garcia's reaction was 4 words: "Clearly, we are being effective." Now here is the part of the story that extends beyond the scheduling dispute. The DOJ's Inspector General announced an investigation into the department's compliance with the Epstein Files Transparency Act. That announcement came the same week the contempt resolution was filed. The IG's job is to examine whether the department actually fulfilled its legal obligations under the law. The DOJ has said it complied. Congressional investigators say the math does not support that claim. The original Epstein archive, according to one estimate, contains over 6 million pages. The DOJ released 3.5 million and declared the matter closed. The gap between those two numbers has not been accounted for publicly. There is also the question of the DOJ's conduct toward Congress during the file review process itself. When members of Congress were given access to a secure government server to examine unredacted Epstein materials, the DOJ logged every search they ran. Bipartisan outrage followed. The department acknowledged the logging and explained it was necessary to protect victim information, the same explanation offered by the department that had already failed to protect victim information in the public release. Then there is the matter of Ghislaine Maxwell. Garcia's statement when Bondi was fired used a specific phrase. He said Bondi had given Maxwell special treatment. That phrase is not a new allegation. It connects to reporting that has been circulating for months about decisions made at the DOJ level regarding Maxwell's case and the materials related to her cooperation with prosecutors. What special treatment means specifically, and what documents would support or contradict that claim, is precisely the kind of question a sworn interview is designed to produce answers to. Bondi has extensive personal knowledge about the Trump administration's handling of the Epstein files. That is the committee's language, and it is language chosen carefully. Extensive, personal knowledge. That is not the language used for a witness with general awareness of department policy. That is the language used for someone who was present when decisions were made. The interview on May 29th is a transcribed interview, not a formal deposition under oath. That distinction matters legally. It matters for what can and cannot be used if the record is ever referred further. Democrats initially sought a sworn deposition. What was confirmed is a transcribed interview. The committee's Democrats have noted the difference and have not withdrawn the contempt resolution as of this writing. So here is where the record stands. A law was passed requiring transparency. The deadline was missed. The release exposed survivors and protected perpetrators. A subpoena was issued with bipartisan support. The subject of the subpoena was fired 2 weeks before she was scheduled to appear. The DOJ argued the firing voided the obligation. Contempt charges were filed. 45 minutes later, a date was set. That date is May 29th. What Bondi says in that room, and what she declines to say, will be on the record. The IG investigation is active. The 2.5 million documents that have not been released are still being withheld. The list of 280 politically exposed persons named in the files has not been made public. The contempt resolution is still pending, and the survivors who testified 3 days ago in West Palm Beach are waiting for the same answers the committee has been trying to obtain since January. May 29th is 13 days away. There is one more layer that has not received the attention it deserves. The subpoena was not partisan. It passed 24-19 with 5 Republicans voting in favor: Mace, Boebert, Cloud, Perry, Burchett. Those are not members known for crossing their administration on major votes. They crossed on this one. When members with those profiles vote to compel testimony from a sitting cabinet official in their own party's administration, the signal is worth paying attention to. It means the Epstein files are not being treated as a purely partisan question inside the committee room, even if they are framed that way outside it. The bipartisan subpoena also made the DOJ's legal argument harder. The DOJ argued Bondi's firing voided her obligation. The committee filed contempt within hours. The question of whether a fired cabinet official remains bound by a subpoena issued in her personal name has not been definitively resolved by any court. The contempt resolution, if it proceeds to a federal judge, would force that answer. Chief Justice Roberts has not intervened in this specific proceeding, but in a different context, he made his position clear. Speaking publicly at Rice University, Roberts stated that personal attacks on the judiciary come from more than one political direction and that judicial independence is not negotiable. He did not need to say more for the message to reach Washington. May 29th may resolve some of this before a court has to, or it may produce new questions that make the legal dispute more urgent, not less.